Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're going to be breaking down recent verdicts and settlements in New York. And these are going to be ranked or ordered by the most recent, the most current. So some of them may be multi-million-dollar results, some of them may be smaller results, and some may even be zero defense verdicts, because they're not ordered in any particular way other than to say, hey, these are all the verdicts that are coming in according to this one database, which is the largest database, Verdict Search, and these are ordered by the most recent. So here's the first case that comes up. This is a verdict that happened after a trial. It was in New York County, which is Manhattan, and it involved a truck crash. So basically what happened here was there was a female plaintiff. She was 59 years old. And what happened was on October 18th of 2018, she was driving in the left eastbound lane of East 125th Street in Manhattan. And she was intending to get on the FDR Drive, which is like a highway, the Franklin Delano Roosevelt East River Drive, which goes, along north and south along the East River of Manhattan. You can go up into like the Bronx, get on the George Washington Bridge, or you can go south toward the Brooklyn Bridge, or even down to the ferry terminal at Staten Island. So anyway, so she was stopped for a red light at the intersection with First Avenue because she was on 125th Street waiting to get onto this FDR highway. And as she was stopped, the passenger side of her car was sideswiped by a truck. And so the truck was trying to make an improper left turn from the right lane. And the plaintiff claimed injuries to her neck. So basically, she sued the truck's leasing company, the owner, she sued the driver. And the case basically was decided, the liability was decided on summary judgment, and they found it to be against the driver and the operator. So the trial proceeded only on the issue of damages. And so what happened was, in terms of damages, after the crash, the plaintiff was taken to the hospital. She had complaints of neck pain. She was not admitted to the hospital. She did not have MRIs. And 1 week later, she went to a doctor who suggested that she start physical therapy. And she did that for 5 months. She had one MRI, and the MRI revealed a herniated disc in the neck at C4, C5, C5, C6, and C6, C7, as well as spondylosis. And she then received 2 epidural steroid injections into the neck, and she eventually had to have a 3-level anterior cervical discectomy infusion. And so she claimed that as a result of this continued pain, she had to resign from her job, because she worked, I believe, as a billing administrator. And so she had to resign from her job, and then she then attempted to work a part-time position, but then she had to resign from that as well, and she could never return to work. And so her lawyer argued that if she was not injured, she would have continued working at the hospital where she was a billing administrator up until the age of 70. And she was 59 when this happened. So the plaintiff's attorney asked the jury to allow for $600,000 in lost wages, as well as $1.2 million in damages based on the plaintiff's life care plan. And the defense lawyer argued that it was a low-speed collision, it was insufficient to cause a significant injury, and also they argued that the plaintiff had pre-existing degenerative conditions in her neck, and that any complaint of neck pain was not causally related to this crash. So, if we say what happened and what was the result was actually a verdict for the plaintiff of $4.17 million. So a pretty good result for the plaintiff. Pretty, significant, a good result. And it broke down as follows. So it was $680,000 for future medical costs, $215,000 for past lost earnings, $275,000 for future lost earnings, $2.4 million for future pain and suffering, and $600,000 for past pain and suffering, for a total of $4.17 million. And so it was a Manhattan trial. The offer was only $100,000. The trial took 2 weeks, and the jury deliberated for 3.5 hours. And it doesn't say how the jury voted, whether it was 6-0 or 5-1, but I don't know if that's such a big, important determining factor. But it doesn't say that, but it does say the amount. Okay, let's go to the next case. The next case is a case in Queens, and this one was decided in May of this year, of 2024. This was a settlement. What happened was in August of 2022, the plaintiff, who was 37, was operating his vehicle eastbound on the Long Island Expressway, another highway. And so when his car was in the center lane, it was rear-ended by a box truck. And so, the driver of the truck worked for 2 different companies as a delivery driver. There was, 2 different companies owned the truck. And so the plaintiff claimed injuries to his neck and back, and he sued both of the companies that owned the truck as well as the driver of the truck, the delivery driver. And the plaintiff alleged that, they were all negligent, and that the owners were vicariously liable for the damage to, for the accident. So then the plaintiff stated that he merged from the expressway's right lane to the center lane before the impact. He said he then brought his vehicle to a gradual stop due to traffic ahead, and he claimed that he was rear-ended approximately 3 to 5 seconds after he stopped. So that would usually be summary judgment, because if you're already, stopping for traffic and you're stopped for some sort of appreciable period of time, like 3 to 5 seconds, and then you get rear-ended, you didn't really do anything wrong. And so the defendant, though, argued that the plaintiff was at fault for the accident. He testified that the plaintiff suddenly entered the center lane and brought his vehicle to an immediate stop in front of the truck. So there were 2 different versions of what happened. Now, in terms of the injury, an ambulance arrived at the scene. The plaintiff was evaluated but declined transportation to a hospital. The plaintiff claimed herniations, many of them, like from C2 all the way to C6, and then with everything in between, as well as L4, L5. The MRI showed a lot of herniations. And the day after the accident, the plaintiff presented to a hospital for an evaluation. He underwent imaging studies and was discharged. He had physical therapy and a series of lumbar and cervical epidural injections, and he underwent a C5, C6 anterior cervical discectomy infusion. And that was done sometime later. That was done in March of 2023. The crash itself happened in August of 2022. So he performed light work for several weeks following the crash. He then stopped working entirely, but was able to return to his job after the surgery. And his job was fairly physical. He was actually a longshoreman, so it's a pretty physical job. The defense argued that the accident did not cause the plaintiff's injuries, and the defense counsel claimed that the herniations instead stemmed from a 2009 soccer injury and a 2010 motor vehicle collision. So like another incident, like soccer injury or another crash, not this incident. That's usually what they claimed. So what happened was that the parties agreed to do a mediation, and they agreed on a judge to, at a private mediation company. This wasn't a court-ordered mediation, this was a private mediation. And at the mediation, the parties agreed to a pretrial settlement of $1.2 million. So also not a bad result, considering the different versions of what happened, the liability issues. It was a $1.2 multi-million-dollar settlement. And it lists a little bit more information, like who's the insurance company. I don't think that really matters. Just it lists who the insurance company is. I know the plaintiff's attorney. They're very good lawyers. I've worked with them. We actually handled some cases together. I recognize some of the experts, like the economist who calculated the lost wages, the life care planner. Actually, both of the economists I recognize. And they don't list who the doctors were. Sometimes they do. Let me see. Let me go back to the first case I did, the 4.17. I just want to see if they list the doctors. Oh, yeah, they do list some of the doctors in that case. Also, oh, yeah, the life care planner in that case I also know. Oh, and I know the surgeon who did the surgery on that case. Yeah, it's helpful sometimes to find out which doctors are in the case. Okay, let's go to the next case, the third case for today. See if we can get to like maybe 3 or maybe even 5. I'll try to speed through them a little bit. Here's a case where this one's in the Bronx. And what happened here was that the case went to trial and it was decided in May of 2024 and involved a female plaintiff who was 39 years old. What happened here was that on July 10th, 2018, the plaintiff, who was a closet organizer, was a passenger in someone else's SUV, which was parked on Pelham Parkway South Service Road near Lerting Avenue in the Bronx. And someone was driving a limo and corporate coach bus on the service road. And as he attempted a right turn, his bus scraped the side of the SUV, and the plaintiff claimed neck and shoulder injuries. So the plaintiff sued pretty much everyone, like the car she was in, the owner and operator of the car she was in, as well as the limo and corporate coach vehicle that sideswiped them. And the lawsuit alleged that, pretty much everyone was negligent in the operation of their vehicles. And plaintiff's counsel argued that the driver of the limo corporate coach should have seen and avoided the parked vehicle. And the defendant's lawyer claimed that the vehicle where plaintiff was a passenger was illegally double parked. And plaintiff's counsel argued that if this version of events was accurate, then the owner of that vehicle was liable for parking her vehicle outside of a designated parking lane. So as a plaintiff, that's kind of like what you usually want to do if you have a passenger. You want to sue both cars and then let the jury or basically let the jury, give them all the evidence, let the jury work it out. I mean, I would think you would probably want the liability on the limo and corporate coach just because they have more of an insurance policy. They might have, let's say, $1 million or more, whereas the car that you're in, like a friend's car, might only have like 25,000 or 100,000. Doesn't say here, but you know what I mean. But it is what it is kind of thing. If the jury finds that they're double parked illegally, they could put the blame on the parked car. If the jury finds that this limo and corporate coach should not have hit a parked car, it's parked and stopped, even if it is jutting out a little, it's parked, you got to see what there is to be seen, then the liability goes on the limo and the corporate coach. So, according to court documents, the plaintiff admitted that he destroyed 5 photos of the crash scene approximately 1 to 2 years after the incident. Okay, so that's not, I'm sorry, that wasn't the plaintiff, that was the defendant, the guy who was driving the corporate coach, that he admitted that he destroyed 5 photos of the crash scene 1 to 2 years after the incident. And so the other driver, the one who was parked, argued that it was legally parked and that the other guy was completely liable, the limo and corporate coach. And her counsel noted that the parked car, the driver of that vehicle, was never ticketed for illegally parking. And so going back to the plaintiff and the injury, the plaintiff did not go to the hospital from the scene. She presented to a chiropractor the day after the crash. She alleged C3, C4, and C4, C5 herniated discs, and she also had a labrum tear and supraspinatus tear in her right shoulder. And initially, she underwent conservative treatment that included physical therapy, massage, chiropractic, acupuncture, and she had arthroscopic shoulder surgery. This was in September of 2018. The procedure included debridement, lysis of adhesions, synovectomy, and a subacromial decompression. So a typical, arthroscopic surgery. She then had a 2-level cervical discectomy and fusion in April of 2019 and received additional physical therapy after the neck surgery. And she testified that she experiences daily pain and claimed that the pain makes it hard for her to sleep. She also stated that she no longer hikes and cannot participate in dance competitions as she did before the incident. The defense argued that the subject incident was minor and could not have caused Barber's injuries. The defense driver, or the counsel for the driver of the limo, I'll call it the limo, noted that there was minimal property damage and that the plaintiff did not complain of pain at the accident scene. The defense further noted that during the plaintiff's deposition, she failed to disclose a 2005 highway collision, and the plaintiff also failed to disclose the treatment, the imaging studies, and the lawsuit that stemmed from that 2005 crash. So that's not good, don't do that. Be honest and tell them everything. The defense specifically claimed that the plaintiff's 2005 MRI showed a C3, C4, and C4, C5 herniation, which is like the same herniation she has here. And the defense concluded that the 2005 collision necessitated Barber's spinal fusion, not this crash. And plaintiff's treating doctor testified that the prior motor vehicle accident made the plaintiff susceptible to the new neck trauma and aggravated a degenerative spinal condition. The plaintiff further claimed that she initially did not mention the 2005 accident because it had occurred during a traumatic period in her life and she had blocked it from her memory. And the parties negotiated a high-low stipulation. So the way a high-low works is damages could not exceed 3.6 million. So no matter what the jury would allow for in the trial, let's say the jury gives a verdict of like 10 million, you're still going to be capped out at 3.6. So that's the high. And then the low was 500,000. So that means if the jury gives 0, you still get 500,000. So you're protected. So that's known as a high-low agreement. You could do that, and then you're bound by the low and the high. So no matter what the verdict is, you'll get, if the verdict is, for example, like 3 million, you just get the 3 million because that's the verdict. But if the verdict is above 3.6, you're not going to get more than 3.6. And if the verdict is below 500, like 495, you still get the 500. So that's the way the high-low works. So what happened here, well, let me give you the trial information first. I know the judge who did the trial. I actually tried a case in front of this judge as well in the summer of 2023. She's a very good judge. So the demand was 5.4 million. The offer was 200,000, and I'm sorry, 200,000 from the limo vehicle and 100,000 from the other vehicle, the parked vehicle. The trial took 10 days, and what happened was that the jury ultimately returned a defense verdict. They determined that the driver of the limo vehicle was not negligent, and the jury did not conclude that the driver of the parked vehicle was negligent, but they also determined, the jury did conclude that the driver of the parked vehicle was negligent. So they decided that the vehicle was double parked, or it was sticking out somehow. It was the vehicle that was parked. It was that driver's fault. But they also determined that the plaintiff did not sustain a serious injury, because you have to sustain a serious injury in order to get over the threshold. And I'm thinking it was probably because of this entire issue with this prior accident that she failed to even mention, where she had the same exact injuries. So then perhaps the jury concluded that her surgery or all her injuries really stemmed from that 2005 accident, not from this accident, and that's why she didn't sustain a serious injury in this accident. That would be the only rational conclusion from this write-up. And so pursuant to this high-low agreement, the plaintiff still recovered 500,000. Specifically, she received 400,000 from this Perez vehicle, which was the limo, and 100,000 from the other driver who double parked. So actually, that was a good deal for her, because she would have gotten 0 otherwise. So the high-low really worked out in this instance for the plaintiff. Okay, let's go to the next case. Here's a case in Richmond County, which is Staten Island. It tends to be more of a conservative venue. What happened here is that on October 18th, 2020, the plaintiff, who was 24 years old and was a line cook and a server, was walking at the intersection of Faber and Richmond Terrace in Staten Island. And so the defendant was operating a vehicle at the same intersection. And that vehicle struck the plaintiff, and the plaintiff sustained an arm injury. And so the plaintiff sued the defendant, and a default judgment was entered against the defendant. I guess the defendant did not appear, did not answer. And then the matter proceeded to an inquest to determine damages. So what happens with that is if you file a lawsuit, but the person you're suing does not appear in the lawsuit, just never answers, like just, I don't know, takes the lawsuit, throws it in the garbage, whatever, doesn't, enter an appearance, doesn't answer the lawsuit. What happens then is, if you file a motion for default judgment, the judge will usually grant it, and you have a default, you have a judgment. But what's the amount, right? How does the judge know what to allow for, what to award you? So that's why they do what's known as an inquest. And so here the injury was that the plaintiff suffered a right humerus fracture. 3 days after the crash, she had to have a surgery known as an open reduction and internal fixation surgery, a pretty serious surgery. And she had approximately 2 years of physical therapy. The plaintiff did not return to work. She sought recovery of lost wages and damages for her past and future pain and suffering. So what happened here was at the inquest, it wasn't really a trial, it was just an inquest, and it was decided by a judge. It was not a jury trial. At the inquest, the judge awarded the plaintiff $751,500. And the way that was broken down was it was $750,000 for the past and future pain and suffering. So both past and future was $750, and $1,500 in lost earnings. I guess they didn't have proof of much lost earnings, so it was only $1,500, but the total was $751,500. So I guess, that's a good verdict, but I guess what they're gonna have to do is either try to collect the verdict against this defendant, which, I don't know if that's collectible, if the person has any money, or if the person does have auto insurance and this person just didn't notify their carrier, or the carrier for whatever reason didn't appear in the complaint, what often happens is they then make a motion to vacate the judgment, vacate the default, and then come in and appear. And then you could settle the case. We actually had that happen in a case recently where we sued someone. I believe it wasn't a car accident, it was more of a premises liability type case. And we also had an inquest, and the judge gave us, I think it was like $250,000. And so, we have this, but it's just a paper judgment. You can't collect any money on it. And we tried to collect, we used the collections attorney, and then finally the defendants woke up and they said, oh, there's this judgment against us. They made a motion to try to vacate the judgment, but as part of it, we negotiated with them, and we ended up settling the case for close to the inquest amount. Well, I think it was just a few dollars shy of the total amount that the inquest was for. So that's pretty good. So we got all the money, and the client got paid. So that's usually what you want to try to do. So yeah, so this is that case. And this case was decided May 21st of 2024, and the incident happened back in October of 2020. All right, maybe let's do one more case and we'll wrap it up. Here's a case also in the Bronx. So this case is back from 2015. So, you see like the dates. A lot of the dates are going to be like 2018. It shows that, like, for whatever reason, my case that I did in the Bronx last year in 2023 was also from 2018. And the case I did this year, which I just got I didn't have the case from the beginning. I got the case, after, while it was already in discovery. But my case was also from, I believe, the summer of 2018. So you could see cases from 2018 are only going to trial now, 2023, 2024, in the Bronx. This case is from 2015, and it only went to trial in, 2024 in May. This is all from May of 2024. So what happened here was on February 24th, 2015, the plaintiff, who was 72 and retired, underwent an amputation of a gangrene toe with gangrene at Jacobi Medical Center, which is a New York City Health and Hospitals facility. And she remained in the hospital following the surgery. On February 27th, 3 days later, she was diagnosed with deep tissue pressure injury on her sacrum, and the wound progressed to a stage 4 pressure ulcer. So this is a bed sore, Decubitus ulcer. And through her attorney, she sued the New York City Health and Hospitals Corporation, and the lawsuit alleged that the hospital staff was negligent in its treatment of failing to position, turn, and prevent these bed sores. And she died of unrelated causes in 2017, and then her estate was substituted as the plaintiff in the lawsuit. And according to her lawyer, she had a history of chronic health issues, including hypertension, diabetes, high blood pressure, and peripheral vascular disease. The estate's counsel contended that the plaintiff was at risk of developing a skin injury and needed to be turned and repositioned every 2 hours after the amputation. And so the allegation was that the hospital did not, the staff turn and position her properly, and because of that, it led to this bed sore. And then once they saw that the bed sore had started, they didn't treat the bed sore and allowed it to progress into a stage 4, which is like the last stage, So then the defense presented medical records indicating that the plaintiff was turned and positioned every 2 hours. The defense also argued that the deep tissue injury stemmed from an ischemic event that occurred during surgery. And so the injury was that the plaintiff developed a deep tissue injury at the hospital. She was subsequently transferred to another hospital, and at the time of the transfer, the sacral injury was documented as stage 3. In April of 2015, the plaintiff was transferred back to Jacobi due to an infection of the ulcer. She was diagnosed with sepsis, and doctors noted that the sacral ulcer had progressed to stage 4. The plaintiff had debridement surgery. Her health continued to decline. She ultimately required a laparoscopic colostomy and a gastric tube placement. She was then discharged to a nursing home in May of 2015, and she still had the stage 4 ulcer at that time. And so the estate sought recovery of the plaintiff's past pain and suffering. And the jury determined that the hospital was negligent, but initially concluded that the negligence was not a substantial factor in causing the plaintiff's injury. However, the jury then proceeded to award money, which it was not supposed to do. So that's known as an inconsistent verdict. That happens. Actually happened to me one time out in Staten Island. It happens. Basically, they're told on the verdict sheet what to do. Like, you have to prove that you have to answer, was the defendant negligent? They said yes. And then they have to say, well, was the negligence a cause of the injury? They have to say yes. Only if both things are true, that they were negligent and that the negligence was a cause of the injury, only then do you allow for damages. How much is this all worth? But if you say, yes, they were negligent, but the negligence didn't cause anything, and then you go ahead and give money, it doesn't make sense. It's inconsistent. So that turned out to... So what happened here was, because of this inconsistent verdict, the judge instructed the jury to fill out a new verdict form. And on the second verdict sheet, the jury concluded that the hospital's negligence was a substantial factor in causing the plaintiff's injury. And the jury then awarded the estate, they awarded $1 million for past pain and suffering. So, pretty good result, I would say, for that kind of case, because it's an older plaintiff, it's a tough case. And so the demand in the case was $500,000. The offer was $150,000. The trial took 8 days, and the jury deliberated for 3.5 hours. The jury vote was 5-1 on the amount of money, on the $1 million. It was 6-0 on all the other questions. And the composition of the jury was 3 men and 3 women, and all 6 jurors were of Hispanic origin, or Hispanic. And then it says here the defense is appealing the verdict because originally the the determination was that the hospital's treatment was not a substantial factor in causing the injury. And, but I think that's a good way to resolve it. I kind of agree with this judge because, look, if you don't do what this judge did and you allow the inconsistent verdict to stand, what happens then is the parties have to appeal. The appeal could take another 2 years. And then the appellate court can't really determine, they can't really say what the jury should have done or whether it was proper or not. All they could say is whether you get a new trial. Okay, so you wait 3 years for the appeal to be decided. Then they say, go do the trial again. Now you're back to square one. You have to do the whole trial over again. It's not really efficient. This is much more efficient for the judge to just explain, hey, this is an inconsistent verdict. You just can't do that. You must have misunderstood something. Somebody misread something. It says so right on the sheet you're filling out. It's like you're answering questions, but they didn't answer it properly. So then they just fixed it. And as long as all of them agreed, I think they should be fine. But I see the defense wants to appeal anyway, but I think this puts the plaintiff in a stronger position because they've won the case. They have a record of what the judge did. There's a stenographic record, and you have the $1 million. You could maybe negotiate a settlement, maybe a little bit less, settle it for like $850, whatever. But the point is that, it was resolved. There's a disposition as opposed to, just being hung with this inconsistent verdict, and then you have to appeal that, and then who knows what, and then it's like a never-ending battle. You don't want that. So I hope this was helpful. We went through some of the recent cases. We could do a few more. I actually printed out 20 cases, but we went through, I think, the first 5. And I'll do a few more in another video. And let us know what you think. Please like and subscribe to our channel. And we are here for you. Our goal is helping serious injury victims and families. Okay, all the best, everyone. Bye-bye.